And are you Joe Jimenez?
Yes,
Counsel, have you received all discovery? Did you review it with your client?
yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Jimenez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, ma'am.
All right. And there's also an enhancement paragraph. Are you proceeding on the enhancement in each count?
So just regarding count one, regarding count two.
Okay. I understand. All right. All right.
Hello guys, you're watching Court Watch. In today's case, buckle up that we're in Judge Boyd's courtroom, and our defendant just realized he's not starring in his own fairy tale anymore. Suddenly he's emotional. Suddenly he's broken. Suddenly the tears are flowing like a leaky faucet, but not a single drop is backed by real remorse. Judge Boyd has seen this exact performance for decades. She's not buying the sob story. She's not handing out sympathy tokens. And she's definitely not here for this man's last-minute Oscar audition. The tension's already thick because the judge knows a scripted breakdown when she sees one. And trust me, she's inches away from cutting straight through the ACTS. Oh, here's the real question. Are these crocodile tears going to soften the sentence, or just make Judge Boyd swing the hammer even harder? Let's dive in.
All right. Mr. Jimenez, did you review the document entitled Court Admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places? In count one, you're charged with aggravated robbery. If the state is able to prove up the enhancement allegation, your range of punishment is anywhere from 15 years to 99 years or life, and a possible fine up to $10,000. In count two, you're charged with unlawfully carrying a weapon with a felony conviction. All right, just one moment. You're charged with unlawfully carrying a weapon with a felony conviction as a third-degree felony. The range of punishment for that offense is anywhere from 2 to 10 years. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Punishment is to be assessed at 15 years in count one, and in count two, they're not. That is, you're right. Okay. So according to the plea bargain agreement, you're to be sentenced to 15 years in count one, and count two, you're to be sentenced to 10 years. Counts one and counts two will run concurrently. Is there anything, because I'm trying to do it from memory at my first glance of the paperwork. All right. And there's a $2,000 fine. Did you understand that to be your plea? Defense is at the plea.
It is, Your Honor.
State is at the plea. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest? To the enhancement under count one, how do you plead? True or not true?
True.
To count two, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and consent to stipulations of testimony with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same.
This man is staring down a potential life sentence for aggravated robbery, and somehow still thought it was genius to grab a firearm afterward and stack even more charges on top. Like, did he think the justice system had a loyalty program? Commit 2 felonies, get the third half off? At this stage, it's not that he failed to learn a lesson. It's that he never even slowed down long enough to consider one. When you're already facing a charge that can bury you for life, the last thing you should be doing is handing the prosecution extra ammunition, literally and figuratively. And now he's in court crying, and honestly, I can't tell if it's genuine emotion or full-on courtroom cosplay for sympathy points. Then again, anyone might start leaking tears the moment they hear the phrase possible life sentence attached to their name. But lucky for him, his attorney pulled off a miracle tier plea deal: 15 years on count 1, 10 years on count 2, running concurrently like a sentencing BOGO special. The real suspense now? Whether Judge Boyd accepts it or decides this man's decision-making is so catastrophically bad that she needs to go beyond it. Should she stick with the 15, go higher? Or if she's feeling shockingly merciful, drop it lower? Because turning a life sentence into 15 years is a massive legal win. His lawyer deserves a trophy, a parade, and maybe a plaque on a courthouse wall. Meanwhile, watching this man act stunned by the consequences he created is the most mind-bending part of the hearing. Because the only person responsible for this disaster is sitting right there in shackles, pretending he just heard about the case for the first time today.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty of counts 1 and counts 2. The court will find you guilty of counts 1 and counts 2. The court will find the enhancement true based upon your plea of true and based upon State's Exhibits 1 and attachments. Are you waiving PSI?
Yes, Your Honor.
All right. In count 1, the court will sentence you to 15 years in the prison, give you credit for any time served. The court will sentence you to 10 years in count 2, give you credit for any time served. In count 1, there's an affirmative finding of deadly weapon. Counts 1 and counts 2 will run concurrently. There's a $2,000 fine. Is there anything else with regards to sentencing?
Yes, Your Honor. He had a federal case that he got 70 months on. He entered custody on May 12th, 2022, which is 3 weeks after this case. And he's been in continuous custody since. I believe he was released from Karnes County, which is the federal penitentiary, where they're holding cell actually, on September 24th, 2024. But he has been in continuous custody since May 12th, 2022, so present.
Oh, he'll receive credit for that time.
Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So here's my question. Why the tears?
I'm citing my last word.
Well, I mean, this is your choices. I mean, this is over you taking some beer with a gun in your hand. Was a beer worth 15 years of your life? Well, the stipulations that you agreed to, I've read it, and you put somebody's life in fear of their life because you wanted what they had. So what I can tell you is, if you want to cry, cry for the person that you put their life in danger when they're just trying to do their job. If people don't want to go to prison, people shouldn't do prison things. Well, I mean, you had a chance to be in the free world, to be with your children and your wife, but you chose this. So this is where we are. If you would have gone to a jury trial and a jury would have found you guilty, let me just tell you, based on my experience, you know what a jury would have done? They would have looked at your tattoos. They would have known what those tattoos meant, because they would have been told what those tattoos meant during punishment, and they would have gave you life, and they would have went on their way. They would have gave you life on that case. And for the gun case, they would have given you the maximum. So if you don't want to be standing before a judge crying about your wife and children, then stop doing this. All right. Good luck to you. Oh, thank you.
Thank you. Very much.
Have a good day.
Oh, thank you. You have a good one.
I honestly thought this man pulled off a full-scale bank robbery with how intense the hearing sounded, only to learn he threatened someone's life over a beer. A beer? You've got to be kidding me. Imagine risking a lifetime behind bars because your impulse control is set to 0 and your IQ decided to take a personal day. How reckless do you have to be to blow up your entire future over something that costs less than $2 at a gas station? And Judge Boyd was absolutely right telling him to pack up those tears. Nobody in that courtroom is buying emotional liquidation sales today. He torpedoed his own life over a can of alcohol, and honestly, he's lucky, extremely lucky, that his plea deal capped at 15 years. Because if this hit a jury, they would have handed him the full life sentence before lunchtime. Moments like this really make you wonder how many lives are destroyed every year because of split-second, zero-thought decisions. So what do you think? Is 15 years the right price tag for threatening someone over a beer? Too high? Too low? Drop your thoughts in the comments. Thanks for watching, and don't forget to like, subscribe, and stay tuned here on Court Watch.